Is it just domestic? No, that's more recent. President Obama mentioned unconventional unconventional hydrocarbons in his State of the Union address. So America is looking at this as an economic surge to get it through the next 20 years, because it'll end in about 20 years, and to solve the jobs problems temporarily. In North Dakota, there are so many jobs in North Dakota. Truck drivers that haul the fluids to and from make anywhere from $80,000 to $100 and some thousand a year, and these trucks are going around the clock 24 hours a day. The train stations, empty out, 500 or 600 people at a time, and they sleep in trailers. This is all reported, by the way, by Keith Schneider, a former New York Times writer that writes for a group called Circle of Blue. His blog is Mode Shift. If you want the big picture, you go to Mode Shift, his blog, and you'll get a lot of this. But 10 workers on the floor of a small trailer, while they're working in the work week. So it's a massive worldwide, also driven by China. China is buying up. They just bought a large portion of the tar sands in Canada. They bought a large $2.5 billion investment in Devon oil, and Devon has a large interest in Colorado. They have a large interest in Louisiana, Oklahoma, their home state, and Michigan and Ohio. Okay? So China is underneath the radar, but they're there. They're right there with a substantial interest. China is driven by a thirst for energy, so much so that they're closing down farms because they need to transfer water to get coal in the north. And they're moving forward at all fronts: gas, coal, wind. They lead us in wind energy technology, this country. Solar, everything. But to keep their economy going, they intend to colonize the rest of the world. Because they can't get farmland, they're buying up farmland by the millions of acres in Africa. All right? And I wouldn't be surprised if they'll soon be buying up land in North America. So the other wild card, big picture, so you have this tension between energy demand, water, and food, and then of course water. Just a little short point here. If you see the bottom bullet next to Keith Schneider's thing here. This spring, for the first time in Colorado's history, someone other than farmers outbid the farmers for the surplus water that they get under Colorado law. They have an auction, all right? They were outbid, the oil companies bid beyond market price, pushed the farmers out of the way and control the water because they want to be able to move it for hydrofracking in their oil and gas development. So it's a very serious situation, this big picture. I'm going to skip climate change. Chris did this. Chris did the frac facts. So, what are some of the things you can do? You can apply those common law principles I mentioned. There's a duty to protect, there's a duty under the public trust law that if activities near a lake or a stream or enter a lake or a stream are going to adversely affect that lake or stream, okay, and there's a public trust that protects it, the state has a duty to consider and determine the likely impacts with sufficient studies before they ever approve anything. You understand what I'm saying? It's a legal requirement under public trust law. And I would say it applies as well to the leasing of minerals and oil and gas off of state lands, like the 23,000 acres that Chris put up here in Berry County that I've looked at. And I mean, it's unbelievable how much of Yankee Springs Township is that. I mean, it looks like about, some of the township officials, I mean, is it what, 80%? 70%? So it's huge. And does a lot of money come back to the township for this oil and gas development?
No.
No. Why isn't that factored in the lease sale? So I would maintain that on the lease sales, that duty applies because the state has recognized that game areas and recreation areas, the DNR right on, if you can go to its webpage and look at its mineral oil and gas programs and its recreation areas, we manage these as a public trust. So they're conceding it's a public trust directly. So then, when you lease property, those of you that have been involved in oil and gas leasing, you know that if you do an oil and gas lease, private or public, you're conveying rights of access to use the surface right, unless it's a non-development lease, like Mike mentioned. But what else goes with that? The right to use water, subject to regulation. And these deeper wells involve, anywhere from 3 to 8 million gallons of water in a 2-week period. In the Nestle case, they did test wells, just to give you an idea of what happens in mid-Michigan here when you put a well in 600 feet from a small little lake and headwaters of the stream. They put in test wells, and they pumped 750 gallons a minute. I think it was for a 5-day test. And on the 3rd to 4th day, one of the observers, one of the stream biologists, one of the observers saw the stream dropping so fast that the bottom line was exposed, and measured a 65% drop in the flow. And that was like a half a mile away from the well. So you have to be very careful to understand the makeup of the soil, the depth of the groundwater that's being used, how much is being used, how rapidly it's being withdrawn, and what the daily rate is, because it can add up to harm pretty fast. Now, is it momentary harm? Yes and no. If it occurs in the critical spawning time, or in critical, when habitat is critical in May and June, just as the water table drops down to the base summer dry season, you can have pretty significant impacts. And in the Nestle case, it was finally permitted by the state at 400 gallons per minute. They said there would be absolutely no effect on the stream. After the trial, the judge said, well, the stream is going to drop between, on average, of 25 to 27% for almost a half a mile, and in the summer as much as 35%. And it's going to drop by 1 to 2 inches. The lakes were going to drop by 4 to 6 inches, these small lakes in the area. So this isn't something to shove under the rug when it comes to water withdrawal. Okay. Now, the other law is the Michigan Environmental Protection Act, Part 17. Under Supreme Court decisions in Michigan in the 1970s, the rule is the state cannot approve a permit until it's done something like an environmental impact statement. Now, the state does require assessments, but it's limited to the well. It does not look at areas outside the well. It does not look at cumulative impacts with other wells in the area, or cumulative impacts that occur over time at that well site, or wells that are added to the well. Because you can have a development well, and then they can add wells to increase production. So that's another law. And any citizen can bring an action. Any citizen can ask the state to do that. And they probably should have done it before they did the lease sale. The state likes to say, oh, the DEQ will take care of it. We don't. The DNR will say, well, we just sell the land. We don't regulate it and protect it. The DNR statute that created the DNR says you shall protect and conserve the natural resources of the state of Michigan. So they have a duty. And they said it's a public trust. And they have a public trust duty to do that. And under the Environmental Protection Act, when you sell leases, what happens when you sell? Once you sell, it's pretty hard to get your land back, right? It's not yours anymore. So it's subject, your use is, getting short.
That was 20 minutes. Do you want to take?
I'll take the Sheldon time. The Sheldon rule. Now, unless you want me to stop. Okay. All right. I mean, we're here. I'm going to do that. I'm doing this as quickly as I can. We're here. We might as well learn what we can. I'd like to learn from you as much as well. So, well, all right. So one of the things you can do is look at your legal rights before the drilling starts. Because all the fracking rules, as you'll see, those are all after the drilling starts, basically. You know, they have to do it a certain way and not make a mistake. Right? They have to discharge an injection well and not make a mistake. But mistakes happen, and risk happens. So that's why New York, Governor Cuomo of New York, in the legislature, first of all, put a moratorium in place while they studied the generic impacts of the whole state of doing this. And then that expired, so the governor continued it, all right, by a moratorium. And then the state has also stopped any leasing of state land for hydrofracking development, the deep shale. Why? Because those state lands are considered to be in the public trust and so treasured that they're not worth the risk. Okay, so federal laws pretty much exempt. There's some laws coming down the pike from EPA on federal lands, and as you've heard about, some on fracking fluid disclosure. The disclosure is after the fact, it's not before. There's no environmental impact being made because at the federal level, there's no permit required under the Safe Drinking Water Act. So without a permit, you can't apply the National Environmental Policy Act and trigger the environmental impact statement, which has been a requirement in this country since the 1970s. Now we have something that's more risky than any oil and gas development in the past, and we're exempting it. We are going backwards as a people. So it's left with the states and the local communities because the federal government has pretty much been hands off. So I'm just,